Good afternoon. The Appellate Division First Department is now in session. My colleagues and I welcome you all to these virtual admission ceremonies. Ms. Guerrero, you may proceed.
Thank you. May it please the court, good afternoon. I, Veronica Guerrero, counsel to this court's Committee on Character and Fitness. I'm honored to present 33 applicants to the court for admission to the bar. Each of these applicants has met all of the requisites necessary for admission to the New York State Bar. Further, I am pleased to report that the committee has examined the records of each and every candidate here today. Accordingly, and on behalf of the committee, I certify that each applicant present this afternoon does possess the requisite character and fitness to warrant admission to the Bar of the State of New York. Therefore, I do hereby move for their admission.
Thank you. Before we rule on your motion, I want to take this opportunity to publicly thank the members of the Committee on Character and Fitness for the excellent job that they have done to ensure that the candidates presented here today are all well qualified for admission to the New York State Bar. The committee's work is very important to us, and they honor us by serving pro bono. Their work is greatly appreciated by all the justices of the court, as well as by the entire Bar of New York State. So I would ask you to please relate this message to them.
I will.
Thank you. Now let's turn to the motion before the court. Justice Cardozo famously said that justice delayed is justice denied. And in our court today, there will be no delay of justice because my colleagues have authorized me to grant the motion forthwith. So that at this time, the oath of your office will now be administered by Susana Rojas, the clerk of the court.
Good afternoon, Justice Gish. Good afternoon, candidates. I will administer the oath in the form of a question. At the end, I will ask each one of you to unmute your microphones and respond by saying, I do, if you agree with the oath. At this point, I ask everyone to please raise your right hand. Do you solemnly swear or affirm to support the Constitution of the United States and the Constitution of the State of New York, and to faithfully discharge the duties of the office of Attorney and Counselor at Law to the best of your ability? Please unmute your mics and respond by saying, I do.
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 Congratulations, attorneys. You may lower your right hand and please mute your microphones. Thank you.
At this point, I would like to ask my colleagues to unmute their microphones so that we can give you the deserved round of applause that you are entitled to. Congratulations. It is customary in our court for one of the justices to give welcoming words to you. And this afternoon, that honor falls to my colleague, Justice Peter Moulton.
Thank you, Justice Gish. 35 years ago, I was admitted in the First Department. I don't remember the justices who were present that day. I do not remember much about the remarks of the justice who addressed us newly minted lawyers. I do remember asking myself, when is that guy going to stop talking? So I will be brief. You're joining a vital profession, one that is a crucial component of government, of the economy, of all aspects of a well-ordered society. It needs good people to run properly, and you are literally our newest recruits. Our legal system, along with similarly independent legal systems in a handful of other countries, is the envy of the world. A majority of nations probably do not have the rule of law as you and I understand it. They do not have fair, fully functioning legal systems. By contrast, in New York City in particular, our state and federal courts are a destination for commercial entities from around the world who, if they must engage in litigation, wish to do so in a form that is free of political or commercial biases and that renders decisions in a reasonable amount of time. Indeed, corporations around the world often write into their contracts forum selection clauses that designate the commercial division of Manhattan Supreme Court as the court where any litigation arising from the contract will go forward. The importance to business of a fair and impartial court system cannot be overstated. Without it, businesses are reluctant to commit capital and take risks. Our legal system has also been a means for moving our nation forward on civil rights. For those of you, probably the majority, who are fresh out of law school, cases such as Brown versus Board of Education, Frontiero versus Richardson, Estelle versus Ruiz are fresh in your minds. Perhaps you read biographies of lawyers who changed aspects of our legal system for the better, such as Pauli Murray, Thurgood Marshall, or Ruth Bader Ginsburg. Perhaps you take inspiration from them. However, you should never consider our legal system to be perfect and immutable. Our legal system is a work in progress, and you all have a role in changing it for the better. A moment ago, I spoke about how well we do in commercial litigation and how we attract the world to our courts. However, other aspects of our legal system are sorely in need of attention and resources. Poor and working class people often have no access to a lawyer in civil litigation. In criminal courts, our assigned defense counsel do an often heroic job, but they're overworked and under-resourced. Having no lawyer or an overwhelmed lawyer is a disability in seeking a fair outcome. Economic status should not determine outcomes in our courts, but too often it does. Obviously, there have been times in our nation's history where lawyers have played a malign role in perverting our legal system. Joseph McCarthy was not a lawyer, but he was assisted by very able lawyers in his red baiting. Lawyers working for large corporations have, on occasion, gotten away with criminality in obscuring the health effects of dangerous products. Prosecutors have, on occasion, acted to support white supremacy in our criminal justice system. The imperfection of our legal system is reflected even in the First Department's beautiful courthouse. If we were sitting in our courtroom right now, you might look up into the stained glass dome in its center. You'd notice the names of a number of legal luminaries, such as John Marshall. However, that cupola also contains the name of Roger Taney, the Chief Justice of the U.S. Supreme Court, who wrote Dred Scott versus Sanford, in which the U.S. Supreme Court held that the privileges and immunities of the U.S. Constitution did not apply to African Americans, whether they were enslaved or free. The presence of Taney's name in our beautiful courthouse is a reminder to me of our imperfect legal system and how all of us as lawyers must work to improve it. How can you do that? First of all, you should do pro bono work for underserved communities. That's truly a win-win endeavor because it will simultaneously help out someone who needs help in a landlord-tenant dispute or a criminal matter or a consumer debt case, and it will give you hands-on legal experience and greater responsibility than you might have in your job as a young associate, as a young lawyer. Second, you should also join one of the numerous excellent bar associations that exist in New York City. The bar association's very mission is to improve aspects of the profession. In sum, remember, as I said, that you're a member of a vital profession that can be an immense force for good. Act with integrity, act with intelligence, and act with heart. Good luck.
Judge Gish, your mic.
Thank you. I was trying to be respectful while I was listening to my colleague, Justice Moulton. But with that, we're concluding today's session of the Appellate Division, First Department. Good luck.
Thank you to all of the justices and to Ms. Rojas. They will log off, and all of the new attorneys will stay on with me.